Thank you very much, and welcome to the 6th in our webinar series, Countdown to the UPC. My name is Paul England, and I'm joined by my colleague Sarah Burkhardt in Munich to discuss the important question of where an action for infringement must be lodged in the new system, and how this affects certain subsequent claims, and whether there is any possibility of consolidating actions together. But first, as we usually do with these webinars, a general update on the most important developments since our last webinar in September. The biggest development in the past 2 months is that after more than 4 years' work and no less than 18 drafts, the UPC Preparatory Committee has announced the adoption of the Rules of Procedure for the UPC. These rules are actually still described as the 18th draft, but this is merely to recognise that matters including the court fees and arbitration and mediation procedures are yet to be added once the committee has decided on them. But the agreement of these rules, which will be at the heart of how proceedings are run in the new court day to day, nonetheless constitutes another major step towards bringing the UPC into operation. Also, at its 11th meeting on the 4th of September, the UPC Preparatory Committee agreed what is called the Provisional Application Protocol. The protocol will allow a provisional operation period for the UPC in which a registrar and other key roles can be appointed. Most importantly, perhaps, for users of the court, this period will also allow the recording of opt-outs of European patents, but not the lodging of the court's first cases. Like the UPC agreement itself, the protocol must be ratified by 13 states. And when this has happened, it comes into operation the very next day. So this means that it will be, or come into operation at least 3 months before the court comes into full effect. Now, as to the official start date of the court in full effect, it's now expected that this will be early in 2017. The other significant news is that Italy has joined the unitary patent. Italy is the 4th largest European country in terms of patent filings, according to the European Commission, so it is an important addition. The only EU countries now outside both the unitary patent and the UPC court regime are Spain and Croatia. Poland, remember, is a participating state in the unitary patent, but not the UPC. So, let's turn to the subject of this webinar. And let's begin by asking what jurisdictional rules we are actually talking about. Well, the UPC is designed to provide, as much as possible, a simplified system of pan-European patent litigation for all the contracting member states. However, these member states cover a wide area. Therefore, although the UPC is a single court, and it's important to remember that it's a single court, it will consist of a potentially large number of local and regional divisions, which are shown schematically in the picture on the slide. It follows that because the UPC has this geographical scope, a party has to know in which UPC division to lodge any particular claim. However, as far as jurisdiction is concerned, there are 2 aspects to the new system. First, the amended Brussels I regulation, recast as it's called, which governs the national and cross-border jurisdiction of disputes in the EU. And the second aspect is the jurisdictional rules governing the UPC itself. Now, Brussels I, as I've shown again schematically in the slide, provides rules of jurisdiction for the UPC as a whole in its relation to the national courts of the member states. So these prevent the duplication of actions between the UPC and the national courts, during either the transitional period and between the UPC and non-contracting member states. Now, we discussed Brussels 1 back in part 2 of our webinar series, and I'm not going to say any more about it here. Instead, we are interested today in the jurisdictional rules governing how actions are properly assigned between the divisions of the UPC itself. This webinar considers these internal rules, which are governed by Article 33 of the UPC agreement, for infringement and certain other actions within the UPC. We are then going to follow early next year with another webinar on how the rules apply to revocation actions. So today, just infringement. So the starting point for discussing the rules governing the internal jurisdiction of the UPC is that the parties to a dispute are always free to agree between them the UPC division in which an action takes place. But we want to say more than that in this webinar, so let's assume that there is no agreement between the parties on the forum. In the absence of an agreement by the parties, Article 33 of the UPC agreement provides the principal rules governing the division of the UPC in which an action must be lodged. Specifically, for infringement and a number of other actions which I shall come to, Article 33(1), subparagraph 1 of the UPC agreement is what applies. Now, before describing these rules, there are some matters to have in mind, which I'll explain briefly first. As regards lodging an infringement claim, a factor in determining jurisdiction under Article 33(1) is the location of the defendant. Specifically, what matters is the defendant's residence or principal place of business, or, in the absence of residence or principal place of business, just its place of business, its regular place of business. Now, it's cumbersome to keep repeating those details in full, and so just to aid understanding in this webinar, we'll collectively refer to this in shorthand as a defendant's domicile. A further matter to bear in mind is that although this webinar is focused on infringement, the jurisdictional rules that apply to infringement actions also apply to a number of other actions, as I said a moment earlier. These are, to list them, actions for provisional and protective measures, actions for damages and compensation derived from the provisional protection of a published but not yet granted European patent application, and actions relating to the use of the invention prior to the granting of the patent or to the right based on prior use of the invention. However, actions for compensation for licenses of right, which are also possible in the UPC, are lodged only according to the domicile factor that I outlined on the previous slide. Importantly, though, please remember that the rules I'm about to describe do not apply to the lodging of revocation actions and declarations of non-infringement. These are treated differently, and we're going to deal with these actions separately in a subsequent webinar. So, let's turn to the rules for lodging infringement claims. There are three basic scenarios envisaged by Article 33(1). The first is represented on this slide in the schematic diagram shown. Here, the box in green in the middle is a central division. The blue boxes represent the local or regional divisions, which I've merged together here for simplicity, and because most of the jurisdictional rules on where to lodge an infringement action don't actually distinguish between local and regional divisions. The same rules apply to both. Instead, the important issue is whether the defendant is domiciled in a member state, represented by a local or regional division, or whether the infringement takes place in one of these divisions. So the slide illustrates a situation in which there is an actual or threatened infringement that occurs or may occur in a contracting member state that is hosting a local division or participates in a regional division, And in this case, the defendant domicile is in a contracting member state that hosts a local division or participates in a local division. So in this scenario, the action may be brought in either the right-hand blue box, which is the local division or regional division of the contracting member state of the defendant's domicile, or the left-hand blue box, which is the local division or regional division of the contracting member state where the actual or threatened infringement has or may occur. Note that in these circumstances, the claimant therefore has a choice of forum in which to lodge the action. In fact, they may have a number of choices if the infringement is taking place in more than one member state that is contracted to the UPC. Note also that there is no option in this scenario to file the infringement action in the central division. And this is why, subject to the two situations which I'm about to describe, the majority of infringement actions can be expected to start in the local or regional divisions of the UPC rather than the central division. So let's just turn to the next scenario. The second scenario, which is depicted on this slide, is where an actual or threatened infringement occurs or may occur in a contracting member state that hosts a local division or participates in a regional division. But this time, the defendant is now domiciled outside the territory of the contracting member states. And this is a situation that will probably not be unusual. In this scenario, the defendant's domicile is no longer a factor in choosing the forum for an infringement action. Instead, in these cases, the action may be brought in the local or regional division of the member state of the infringement, or now in the central division. So now the central division has come into play, but the claimant still has a choice available to it. And again, that choice could be quite broad. That is, the more member states represented by a local or regional division in which an infringement is taking place, the more options available to the claimant. So let's turn to the third basic scenario. This is the third one envisaged by Article 33(1). And it's where the defendant's domicile is outside the contracting member states, and the contracting member state this time, where the infringement is occurring or may occur, doesn't have a division. So in these circumstances, the action must be started in the central division, and consequently there is no choice here for the claimant. However, as you may appreciate, this scenario is likely to be rare. And that's because, although we don't yet know for certain which member states will not have a division of their own, it's probably only going to be one or two. And so for this scenario to apply, the infringement or threatened infringement would have to occur in one of those states without a division, which will be the minority, alone. I'm just going to run through some examples before I hand over to Sarah, just to illustrate how these rules might work in action. So if the place of infringement is Germany, and the defendant's domicile is France, what is the choice of forum? Well, there's a choice for the claimant between the German local division and the French local division, assuming that France will have a local division, which is probably a safe bet. Turning to the next example, so that was roughly equivalent to, that was an example of the first scenario that I described. Turning to the next one, if the place of infringement is France, but the defendant's domicile is the US, the choice of forum becomes French local division, or now the Central Division, because the US is not based, a US domiciled company is obviously not in the contracting member states of the EU. In the third example, we've got the place of infringement is Malta, and the defendant's domicile is again the US. On this occasion, on the assumption, and it is just an assumption at the moment, but probably quite a good one, that Malta doesn't have a local division or doesn't belong to a regional division, the only option, given that the defendant is domiciled in the US, is for the case to go to the Central Division. So in the last example, the place of infringement is Estonia, and the defendant's domicile now is the Netherlands. Again, here, the claimant has a choice. It can go to the Nordic-Baltic region, to which Estonia belongs. Estonia doesn't have its own local division, part of the Nordic-Baltic regional division, or the claimant can go to the defendant's domicile in the Netherlands. With that, I shall hand over to Sarah Burkhardt in Munich.
Thank you very much, Paul. What happens if a claim to one of the actions to which Article 33, Section 1 applies is followed by a further such claim? The actions in question are those we saw earlier. 1. Actions for infringement of a patent and/or an SPC. 2. Actions for provisional and protective measures and injunctions. 3. Actions for damages or compensation derived from the provisional protection conferred by a published classical European patent application. 4. Actions relating to the use of the invention prior to granting of the patent or to the right based on prior use of the invention. Or 5. Actions for compensation for licenses on the basis of Article 8 of the Unitary Patent Regulation, which is the EU Regulation number 1257/2012. If an action is lodged in a division of the Court of First Instance for one of these actions, and subsequently another one of these actions is lodged between the same parties and concerning the same patent, the subsequent action must be brought before the same division as the first action. For example, a party that has brought an action for infringement of patent A in contracting member state X on the basis that this is where the defendant has its place of domicile cannot later seek an injunction against the same defendant on the same patent in another member state Y, where the infringement is alleged to occur. According to Rule 208, Section 3, when an infringement action on the merits has already been lodged, an application for provisional measures must immediately be forwarded by the registry to the panel to which the action on the merits has been assigned, or the single judge concerned. We addressed the lodging of revocation claims in a later webinar, but it is important to consider here what happens when an infringement action is lodged subsequently to a revocation claim in the Central Division between the same parties and concerning the same patent. As the diagrams on this slide show, in this situation, Article 33, Section 5 provides a choice of division in which to lodge the infringement action if it follows the lodging of a revocation action. Firstly, the infringement action may be lodged in the Central Division together with the revocation claim. Or secondly, the infringement action may be lodged in a local or regional division according to the domicile or place of infringement rules in Article 33, Section 1, already discussed. If the infringement action is lodged in a local or regional division, there is now a split forum between actions which concern the same parties and the same patent. In this situation, the split forum becomes subject to a decision whether to join the actions or keep them separate, which is taken by the local or regional division under Article 33, Section 3. In particular, the Article 33, Section 3 decision may result in the infringement action being moved to the central division. We will address this matter fully in our next webinar. If a revocation action has already been lodged, and if a preliminary injunction or other provisional or protective measure has been lodged in the local or regional division, a subsequent infringement action concerning the same parties and the same patent must be lodged in the same division. There are a number of measures in the UPC for avoiding duplication of actions, simplifying actions, or increasing the efficiency with which related actions are heard in the court. Duplication of actions could arise theoretically if an action between the same parties on the same patent were brought before several different divisions. However, Article 33, Section 2 ensures that if this happens, it is the division first seized that is competent to hear the whole case, and the other divisions must declare it inadmissible. However, actions that concern the same patent, in which there is no identity of the parties, may proceed in different divisions. So, a claimant in an infringement action against X may need to lodge a separate action against another party, Y, in another division. Where allegedly infringing activity affects territories represented by 3 or more regional divisions, a defendant can request that an action pending before a regional division is transferred to the central division. Lodging an action in a regional division may therefore bear the risk that the defendant takes over control on the choice of forum. Therefore, claimants should carefully consider whether to bring an action before a regional division at all. A similar transfer is not possible for alleged infringements affecting multiple local divisions. The result described in the previous slide, where a claimant may have to pursue more than one defendant in more than one division, may, in certain circumstances, be prevented. If there is more than one potential defendant domiciled in more than one contracting member state, and they have a commercial relationship, and the action relates to the same alleged infringement, Article 33, Section 1b says the action may be brought against all the defendants in the place of domicile of one of them. The consolidation provision applies in particular to infringement actions, actions for provisional and protective measures and injunctions, and actions for damages or compensation derived from the provisional protection conferred by a published European application. The question is, what is a commercial relationship and what is an action that is related to the same alleged infringement? I will come back to this in a moment. Where it is for the proper administration of justice and avoiding inconsistent decisions, Rule 340 provides that actions concerning the same patent, whether or not between the same parties pending before different panels in the same or different divisions, or different panels of the Court of Appeal, may by agreement between the parties on account of the connection between them be heard together. Let's look at the multiple defendants rule and the general joinder rule in a little more detail and ask how they compare. The first thing to note is that Rule 340 is, in some ways, drafted in more general terms than the multiple defendants rule. For example, it applies to revocation actions concerning the same patent. It allows these to be heard together, whether or not the claimants in those actions are commercially related, providing the parties agree to it. It also appears that the general joinder rule may be applied to infringement cases where the multiple defendant rule fails because the actions do not have a sufficiently close commercial relationship for the purpose of that rule. It should be noted, however, that the effect of the general joinder rule is different. The multiple defendants rule allows defendants to be joined in a single action. Rule 340 on general joinder merely provides for actions to be heard together. Nonetheless, this may be of considerable practical benefit to a patentee or exclusive licensee who is enforcing a patent against a number of defendants in a number of separate actions. The difficult question at this early stage is what is meant by the words "on account of the connection between them" for the purpose of Rule 340? And what does it mean when it says to avoid inconsistent decisions? These may simply refer to situations in which the same patent is at issue, but they may also require that the same acts of infringement activity are taking place with the same product. Similar questions arise about the application of the multiple defendants rule to cases where there is the same alleged infringement. Does this mean that the same product is infringing the same patent? Cases from the CJEU concerning the cross-border infringement in similar scenarios suggest this. They also suggest that the multiple defendants have a commercial relationship when they are members of the same group company. However, accurate answers to how these rules are to be applied must be worked out by the judges of the UPC when it is enforced.
Thank you very much, Sarah, and thank you very much from me and Sarah to all of you who have logged in for that session. The slides will be, and the recording will be sent to you shortly, and we will be placing this webinar together with our 5 previous webinars on our UBC web page, so please look out for that, or do get in touch with us if you'd like us to send you a link. And thank you also for those of you who have written in with questions. We won't deal with those now. We'll get back to you shortly and give you proper written answers, which we think you might prefer. But thank you for the time being. And just to repeat that our next webinar will be on revocation claims, bifurcation and transfer. With that, thank you and goodbye.